Hello everyone, I am Monalisha Padhi. I am a legal intern at LEXIS and Company, and I am a third year student of Bharati Vidyapith New Law College, Pune. I am a student of BBA LLB, and today's topic is essentials of a valid Muslim will. Any Muslim, including a man or woman who is a major and of sound mind, can make a will. Regarding wills, the age of majority is governed by Indian Majority Act. A will made by a minor is invalid, but it can be validated by ratification after he attains majority. A person of unsound mind is not competent to make a will, and will made by such person is invalid. Will made by a person while of sound mind, who later becomes of unsound mind, becomes invalid. In Abdul Manan Khan versus Mirzuta Khan, AIR 1991, Patna High Court held that any Mohammedan having a sound mind and not a minority may make a valid will to dispose of the property. So far as the deed is concerned, no formality or a particular form is required in law for the purpose of creating a valid will. Unequivocal expression by the testator serves the purpose. Will of a person committing suicide. Under Sunni law, the will of a person committing suicide is valid. Under Shia law, a will made by the person who was done by any act towards committing suicide is invalid. But if the will is made before doing of any act towards committing suicide, it is valid. Competency of the legatee. Any person capable of holding property may be legatee under a will. Thus, age, sex, creed, or religion are no bar. However, no one can made be beneficial owner of the shares against his will. Therefore, to complete the transfer of the legatee, must give his express of implied consent to accepting the legacy. An institution can be a legatee. A non-Muslim can be a legatee if he is not an enemy of Islam and is not hostile towards Islam. In Sunni law, a testator murderer cannot be a legatee. In Shia law, if the act of murder was an accident, he can be a legatee, otherwise not. And one person. In Sunni law, a child born within 6 months of the date of making of the will is considered to be existent and is a valid legatee. In Shia law, the period is 10 months, which is a maximum period of gestation. Bequest for a charitable object is valid. Validity of the subject of will. To be able to will a property, it must be capable of being transferred. Second, in existence at the time of testator death, even if it is not in existence at the time of making will. Thus, a bequest cannot be made of anything that is to be performed or produced in future. Third is in the ownership of the testator. A bequest that is take effect only upon any a certain event happening is a congenital bequest and is void. However, a bequest with the condition that derogates from its completeness is valid and is void. For example, a grant is made to X for his life and then is stipulated to go to Y after death of X. In this case, X will get the grant completely and Y will get nothing. Thus, a bequest of life estate is not valid under Shia or Sunni law. Extension of power of will. The testamentary power of a Muslim is validated in following two ways. Limitation as regard to person. The general rule is laid down in Ghulam Muhammad versus Ghulam Hussain 1932 by Allahabad High Court that a bequest in favor of an heir is not valid unless the other heirs consent to the bequest after the death of the testator. Whether the person is an heir or not is determined at the time of testator death. Under Shia law, a testator may bequest on an heir as long as it does not exceed one third of his property. No consent of other heirs is required. In Hussain Begum versus Muhammad Mehdi 1927, it was held that if all the property was bequested to one heir and other were not given anything, the bequest was void in its entirety. What is the difference between gift and will? A gift is an immediate transfer of right or interest, whereas will is a transfer after death. Will gift is a delivery of possession is necessary. In will, delivery of possession is not necessary. In gift, subject of gift must exist at the time of making gift, whereas subject of will must exist at the time of testator in the case of will. But in the case of gift, right of donor is unrestricted, but in will, it is limited up to the one third of the property. In the gift, it cannot be revoked, but in case of will, it can be revoked by making another will. That's all for the topic. Please like and comment on the video and please subscribe the channel. Thanks.